We are live.
Good afternoon, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Friday, February 10th. It's 1:13 in the afternoon. We're here to go over draft of 87, which is the Earned Access Bill, Earned Wage Access Bill. So the Legislative Council has been working with Department of Financial Regulation and redrafting the language. So we have David Hall from the Legislative Council to walk us through the redraft. Welcome, David.
Thank you. Good afternoon, everybody. David Hall, Legislative Council. So what is posted and what is now on your screen is a committee strike-all amendment. Is Representative Chase online?
Yes.
Okay.
Hi there.
Hi, hello. I was Representative Chase. I was looking around the room considering who might be new to committee amendments and thought I might explain what's going on here.
Thank you.
It's good to know you're behind me or in the ether somewhere.
Yeah, thank you.
So after your first hearing on H87, an act relating to earned wage access service providers, the Department of Financial Regulation and industry types, proponents, others, I suppose. I don't know everybody because I wasn't part of it, but they worked together to discuss the bill, and I received comments helpfully from the department in 2 rounds, and I have tried to incorporate that into new language. This is going to be, and I apologize, but it's going to be a little bit hard to follow, and that's how it works when we get to the end or to the meat of a markup phase. We have to start looking at words and organization, and it's super helpful to have the regulators and the industry affected folks work on the substance because I don't know the substance and they do. So I'm appreciative for that. There are places in here that are highlighted in yellow, and those are the changes conceptually or linguistically that came to me relative to the bill as introduced. There are also places with brackets or highlight or italics that I'm going to dwell on just to flag places where either I reworded some language or might suggest a reorganization. And to everybody's credit or benefit of the doubt, they have not had a chance to see what everybody is seeing right now because it's the way time flows around here. So more work will need to happen. But I am going to go through this and advance the ball. So a committee amendment is the format of the language that you have posted on your screen. So once that bill, once the request came through and was released, it was assigned the bill number H87. This continues to live as H87, but now, you had the version of the bill as it was introduced. And the committee, which has possession of that bill, is now recommending to the House the way that the House should change that bill. Okay? Only the House can amend a House bill. The committee makes recommendations on how that should happen, whether it should happen in what way. That can happen in 2 different forms of amendment. You can have what I sometimes call a surgical amendment, which has instances of amendment and says, first, by amending the bill in section 1 in 8 VSA, 2301, by striking out the definition of automobile and inserting a new definition. And that'll be discrete and it'll have a few instances of amendment. The other way it happens is through what's called a strike all amendment, which is what you have here. So we are saying to the House, for H87, you should strike out all of the matter after the enacting clause and just do a wholesale repopulation with this new matter. So that's what right now this proposal is for this committee to propose a strike all amendment to the House. Okay?
Generally, for here, I like going the route of a strike-all amendment for the simple fact that when it gets into the calendar, you read the whole text. You don't have to, look up the bill and then try to figure out what was changed, and then it's easier to read it when it's all in one place. So as much as possible, we try to put a strike-all here anyway.
So you'll see that denoted in the lead-in language in these first 6 lines. So to the House, as I said, you're making a recommendation to the body. This committee, which was referred H87, meaning you had possession of this bill, respectively reports is considered the same and recommends that the bill be amended, and here's the strike all part, by striking out all after the enacting clause and inserting in lieu thereof the following. Okay? So we're going to have a few more sections than we had before. Section 1 is where we create this new chapter in Title 8. It's a new chapter 75. That's why it's all underlined, because it's brand new language. And remember that what you're seeing on your screen is telling the world what you propose to do to the statutes, not to the bill necessarily as it was introduced. So the underlines are new language relative to the existing law. Strikes would be strikes against existing law, not against the bill as it was introduced or any other version of the bill as it's floating around in the building. Okay? So that's why we are all underlined here, because this would be a brand new chapter in Title 8. We still have Section 2301 definitions. So two, I tried to reword a little bit. The new concept here is that this amount of wages, compensation, or other income, this would be determined by the provider. It's based on information submitted by a consumer or by an obligor, and it is the amount which at the time, or an amount which at the time of the payment of proceeds, it's what the obligor owes but has not yet paid to the consumer. So my whole effort in this, as with so many places in this bill, is to try to simplify the language just to the extent we can, but I am not trying to change the substance more than what has been proposed. So I will trust the parties involved to review all of this and say, your attempt at brevity cost us some clarity or some substantive information that was relevant that we need to put back. And I will welcome that. Okay. Earned wage access services is the same. 4 is changed simply because we're moving the terminology from register to license. Okay. So rather than a registrant, later on, we'll have a licensee as a provider who has been issued a license. So mandatory payment still means an amount that a consumer must pay to a provider as a condition of receiving proceeds. Number 6 is bolded here. Because I think that it might be more useful in the organization of this chapter to have a separate section that deals with payments, mandatory and non-mandatory. And the reasons are several. First, if I'm following this correctly, I think the construct we're trying to create in Vermont is that you have to have a free based system of services as a baseline level. And then you can have an enhancement that is non-mandatory, for which they do charge other charges. But if that's true, then I think we need to say that somewhere a provider or licensee shall not impose a fee or charge for earned wage access services. 1, proposition. 2, proposition. A provider may impose non-mandatory payments for additional services at additional cost, and then have some examples. So like in the way that this is put together right now, for purposes of this section, examples type language not only is that usually more than we would say in a definition, but also it changes or sees, it wants to impose this substantive requirement that this counts as an example of a non-mandatory payment, but that's only if you have a a structure in which you provide these services at no cost. You see what I'm saying? So that's not really an example. That's rather an either or proposition that includes a mandatory requirement, right? It only counts as non-mandatory or a no-cost option if what you're doing always features that that option to have services for free, basically. It's the same with the bold language starting on line 21 here. So it even says, like in line 1, shall satisfy the requirement to provide an option of receiving proceeds within X days. So these are all, in my view, there's a lot of substantive law embedded in this definition, and we're really trying to move to a place where we get away from that, where a defined term is just the term as defined. And then if we have other requirements that relate to what something is or is not, the ones and the zeros on how, conditions work or don't work, requirements are imposed and exceptions are created, that all should go down below in substantive law. So I can work on that if you want me to, and it's not going to change the substance of what's here. It's just basically going to change where it is. Everybody comfortable with that? Non-recourse, mostly the same. It means that unless it's otherwise permitted in a new section down below, the provider can't compel or attempt to collect these proceeds or non-mandatory payments. And I see there the term outstanding proceeds, so that negates a comment I have somewhere else. So a lawsuit action or proceeding, this is all language is streamlined a little bit, but substantively it's the same. Arbitration or ADR process, third-party collection. 4 is new, sale to a third-party collector or debt buyer of outstanding amounts or obligations of a consumer or any rights against or with respect to a consumer or the consumer's property, assets, or accounts, or other means. So, there's a bracketed question in here. Do we need to say this? Other means is extremely broad. What do we mean? Should we use the including construct here? And what is the difference between, in lines 4 and 5, including actions with respect to a consumer's property, assets, or accounts versus 1 or even 2, 3, or 4? I'm not sure I know the distinction. I see the distinction there. Seems like that might be subsumed within the other ones already. So that's just a flag I have that others can respond to and say, we like it the way we did it, leave it alone. That's fine too. Same kind of note here on lines 10 and 11. Is there a need to more fully flesh out what we mean when we are talking about non-recourse and the basis of, when things can be collected? Maybe this subdivision B here, rather than being embedded in this definition, is an exception below to licensee requirements and says, where the licensee is not allowed to try to collect or compel repayment, the exception should be unless the consumer receive those proceeds with the intent to defraud, right? You see, I know that this is really like deep level inside baseball relative to the policy questions that you're debating, but I want you to know why I've put these questions in the body that I have. And I haven't made those decisions and just brought you a new draft that deviates from or too much from what was given to me because, again, there could be good reasons to leave things the way they are. Obligor stays the same. Outstanding proceeds, I noted that this wasn't a defined term otherwise used in the draft, but that's, my search was wrong because I see it up here above, so I'm gonna disregard that one for the moment. And move on to proceeds are the same, providers the same. So for unique identifier, we got rid of the definition of NMLS, which had appeared in here. We only use the term unique identifier one time later on, and it is a unique identifier assigned by NMLS. It appears in the requirements for what a licensee must do, and it says they must disclose their unique identifier assigned by NMLS. So I just wasn't sure if we still need this to be a defined term, if that's only used once and it's in a pretty clear context of what we mean. So 2302 license required. Again, this is in lieu of registration. We're using a different term and protocol. So, quick note in subsection A here, we're truly trying to move away from having dates in statute that kind of grow old. I think we can handle this through the implementation piece below, but I just wanted to flag it. So the simple duty is a person shall not provide services without a license. B is new language. I did see this. It's stock, more or less, language from many other, similar constructs in law in which this is based. So I don't love it, but I understand the need to be consistent with the way we've said it in other places. So I didn't bother with trying to rephrase it, but it's there. So subsection A, this one's new on subsection C, the top of 6. Subsection A of this section does not apply to a financial institution as defined if its deposits are federally insured. So if you're a federally insured financial institution, you don't actually have to get a license to provide earned wage access services. You can ask about, why they think that's a good idea. Usually we don't require duplicative licenses if we feel like people are being regulated enough with what they do. All right, so 2303 application, I should say an applicant shall include in its application for a license. So we've got, this is all new stuff. Description of the services that they want to provide here, a list of the other states where they operate, nature and amount of non-mandatory payments, information about bankruptcy, name and address of institutions through which it would provide these services, other persons that it has plans or does contract with to provide services, any other information required by NMLS or the commissioner. So licensee requirements. So a licensee is subject to the following requirements. I think, between license requirements and then prohibited acts and practices, there's a lot of room, and I know this was probably based on another state. I think there's a lot of room here to clean some of this up, eliminate some redundancies and make it clearer. And the simple construct is shall and shall not. So we have a list of the things that a licensee has to do. We have a list of the things the licensee doesn't have to do. I haven't gone through that entire exercise here. You certainly did that when we went through the rewrite of a lot of Title VIII a few years back. It's tedious. But it's important, you want the language to be accessible and simple as possible. So, a licensee is subject to the following requirements. Here I just say, a licensee shall, 1, provide proceeds in a non-recourse basis and treat mandatory payments as non-recourse obligations. 2, I rewrote this one just a little bit to say, you shall provide a written or electronic notice of your terms, and then B relates to the things that will go in the notice or features of it. So use language easily understood, state they have jurisdiction, provide a phone number and a website, state type and amount of non-mandatory payments. So 3 is new. The concept is new, and I just sort of reorganized and rephrased this. These are the bases. So it's a shall not here. So again, this may like go down into the shall not part of a combined section. But anyway, they shall not collect, compel, or attempt to collect or compel repayment. I don't know if you need to say collect and compel. I don't know if it's necessary to always say, attempt. I don't know how granular it gets. Like once you're out in the world and you need to enforce against people, do people really try to say like, well, we didn't actually collect, we only attempted to collect? I mean, if people do make that argument in good faith, I would find that offensive, but I don't know. I'd be interested to know. Because you see this in federal statutes and there's like 50 verbs in there, like, and then a catch-all at the end too. So I have a tendency sometimes maybe to overcut. So again, to the people in the room, my apologies. And if I've gone too far, let me know. But I would thin this down even a little more if you'd let me. But a licensee shall not collect except as follows. So a provider may recover the amount of proceeds or non-mandatory payment. So the first one here is through an employer-facilitated payroll deduction from the next paycheck after the date of payment proceeds pursuant to an agreement with the consumer and obligor. You may attempt one additional payroll deduction if there's a failed or partial deduction due to administrative error. What does that mean? We say that in 3 is used here. That error includes an application, programming interface malfunction, or a mistake in the payroll process, including a miscalculation of base pay or overtime. That error does not include a situation in which the employer has garnished an employee's wages following a payment of proceeds. B is another option. You can initiate and authorize direct withdrawal from a consumer's depository account at a financial institution using ACH if the consumer has authorized that provider to initiate that withdrawal in compliance with the ACH rules. Provider may attempt to withdraw only on the dates to which the consumer agrees, provided the provider make no more than 3 attempts at withdrawal. Provider shall use reasonable care to avoid directly causing consumer to incur overdraft fees. Provider may submit, I didn't quite understand C, that's just, I'm not familiar enough with the world, but it says a provider may submit a periodic written invoice to the consumer for payment of the outstanding proceeds and non-mandatory payments. And it says provided that the obligor shall cease invoicing the consumer after sending 3 such invoices. So I am going to phone a friend for explaining that one when somebody has the chance. And then D, the catch-all here, provider may use other means of collection that the commissioner approves by rule or order. So at least there's other than these 3 A, B, and C examples, there may be other ways approved by the department that they could use. Did I see a question?
Yes, question. So I'm just curious in terms of parity, though I'm trying to absorb these changes all quickly too, so maybe I'm missing something. So back up on very top of page 8, where it talks about a licensee shall not collect. Sorry, I'm not going to go re-traumatize you with all the verbs, but anyway, so 3A, where the provider may recover the amount of the outstanding proceeds, et cetera. Not more than 1 time it may attempt to do it. And then when it gets directly to the consumer, it's not more than 3 times. I'm just wondering why there's a difference there, because the consumer, I'd like to, generally I think parity is good, but I just want to try to understand why there's a different number of attempts that can be done to an individual's basically bank account versus, again, I'm reading this quickly to follow along with you, but compared to the employer's payroll system.
Yeah, I think it's a good question. I don't know the answer.
Okay. I'm listening. I just really want to I'm trying to listen as we're going here. Okay.
Yeah.
Okay, great. I'll give myself a star. Okay.
4, a licensee shall inform a consumer the day will first attempt to collect repayment. So here 5, a licensee that seeks repayment of proceeds from a consumer's depository institution account shall comply with applicable ACH rules. I mean, it's sort of separate from 3B above. Up there, it says, if the consumer has agreed to allow it, provided they are doing it with the rules, and then here's sort of a separate duty imposed on the provider to comply. So maybe licensee shall permit a consumer to cancel participation at any time without a charge. Here's the piece about licensee shall clearly show the unique identifier issued to it by the NMLS, any solicitations and advertisements, any other documents the commissioner requires with rule or order. Yeah, go ahead, please.
I just want to go back to your thing with the provider or the obligor and the consumer. So the consumer is any person, it's not defined, but I think it's any person who could use the services, and the obligor seems like somebody who has signed up for the services.
A consumer is an individual who lives in Vermont, and the obligor is the person who owes the consumer money for work.
The obligor.
To the extent it's helpful, that's a typo. It should have said provider.
Okay.
Thank you. And so, question that if I had time, I would have asked the department earlier and not caused all this confusion. I apologize. I thought it was, but not entirely knowing, how this works. I don't want to change something and not have a good basis for it. So I apologize for the confusion. Does that straighten things out for you?
Knowing that it's not supposed to make sense, then yes.
Well, so what's happening in C here? So that's from what I understand, this is the periodic invoice option that's available to a provider who is trying to get paid back for the proceeds it has issued now. And so this is saying one of your options, rather than doing a direct deduction from your account, for instance, through ACH, one of the options is that you provide a periodic written invoice. And it should say, provided that the provider or the licensee, really, will cease invoicing the consumer after sending 3 such invoices. So knowing that does now flow to the provider, I presume that means if they haven't paid you after 3 times, we're getting into debt collection, fair practices, consumer protection. Don't send more than 3 notices, 3 invoices. You're not getting paid back. That would be how I read.
And we've said no debt collection.
We have said that. We've said you can't charge for this basic service. We've said you can't recover these amounts unless it's fraud. We've said you can't sell this to a debt collector or sue you or try to take your house or any of that. So any questions further on that?
I guess I'd just like to understand what periodic means. I mean,
Sure.
there's a simple way of just saying that they can submit no more than 3 written invoices to the consumer for payment.
I mean, periodic there just serves the function of saying it's some regular basis, but we don't say what. We're not telling you have to do it weekly or monthly or bi-weekly or every 30 days. We're just saying if you're going to set up a schedule, fine, that's one way you can do it. But if after 3 failures to pay or unresponsive responses from the consumer, it's time to stop sending bills.
Just on that, so on that point though, because it's a different world, but and this is not enough to UVM Medical Center, but sometimes those bills come like a year out. So I do think it's important for a reasonable amount of time to be defined in here. I know we're talking about much smaller numbers, but it is always a delightful surprise to receive a bill, 8 months after in this case is like a lab or whatever. So I do think it's important so if we're trying to be clear and make sure it's reasonable on both sides, that we have some sort of timeline attached to this. So I would define periodic or put something in there. Maybe that was enough to UVM Medical Center. I think you need to work on your billing, but anyway, so.
Seconded.
Yes, I'll take a third. Yeah.
That would be the last one.
Okay, fine. Yes. And there are no friendly amendments either, as I understand it.
let's see. Here on page 10, subdivision 8 here. This is new. So basically it's saying anytime that you are giving this option or soliciting some non-mandatory service, so your enhanced services, they aren't required, but they are optional. The provider has to prominently disclose that the earned wage access service is available for free and any payment is optional. Under B, the disclosure has to describe how customers may access the no-cost options. And C, the no-cost options can't be substantially more difficult or burdensome for a consumer to access than options involving or requiring non-mandatory payments.
Are we just listening or are we adding?
You can ask questions now. I mean, we're gonna go, so I think the process is gonna be, we're looking at this, I think David will work with the department and the advocates as well, to bring us back a clean copy on Tuesday, if possible. So that then we can go through it, but I think it's good to ask questions now.
Great.
So that we can get them answered as much as possible. So maybe it's possible we can vote this out Tuesday.
So when we're talking about describing the no-cost options, isn't there some kind of standard language that says in an easily to understand way, right? Like, is that something that we want to, just because somebody is explaining it doesn't mean that it's not buried or easy to understand? I understand the next one talks about not substantially more difficult, but I don't want anybody to miss that.
So to your direct question, is there a standard way? No. I mean, there are plenty of ways that is manifests in all kinds of different places. Can you do it? Of course you can.
Just,
Should you? That's
It's
your,
repetitive.
that's an answer.
just remember that this is kind of the template for DFR.
Yep.
And now they're gonna take it and they're gonna create rules around this.
Okay,
So they'll be more prescriptive to the parties they're regulating or that want to be licensed.
okay.
Prohibited acts and practices. So, a provider shall not impose a mandatory payment on a consumer that directly relates to the provision of earned.
Heather has a question.
I missed it, I'm sorry. Oh,
Oh, sorry. Can I ask my question now?
Yes.
I'm jumping around and I can wait until the end, but it's on the non-mandatory payments and tipping. So I think we went by there really fast, but before we close, I just want to have some explanation on that and put in my 2 cents.
Okay.
I wrote down section 6, so I don't know.
Go ahead, Heather.
Well, my understanding from the last time we discussed this, that there was one company that had tips and it was set up as a default to $2 or something. Number one, I don't think we should have tips at all for this service. But if we do have tips, if we do allow them, there's something in my way of thinking that it's a bit predatory to go in and have a free option or an option that's $1.99, but then you're charged $2 and then you're charged $4 almost on a $25 advance. So I have some issues with the tipping in general. And I don't know where that was. Is that the spot? Isn't it down a little bit? So
I don't actually know off the top of my head when or if the bill says tips, but it's a non-mandatory payment. So anything that relates to non-mandatory payments would apply to the practice. And that does come up a little bit in this section 2305 here.
and can we say no tips?
We can say whatever you want.
Well, I don't think you should be tipping and have it defaulted so that people overlook it. And so I don't like that part of the whole system.
I guess I'm not following.
I think it's the, no non-mandatory payments should be able to be chased for a default. So if somebody chooses to make a non-mandatory payment, is there an option for the company to chase them down for a default? If it's a non-mandatory payment, there shouldn't be one, is I think what Heather's saying. So if somebody says, I'm gonna make a payment and then they don't,
Heather, are you saying that no default period?
Let me regroup and try to articulate it a little bit better.
I hear what you're saying. You're saying in the universe of non-mandatory payments, you want to disallow the ability to ask for a tip, right?
Yeah, that's exactly, oh my God, that's exactly what I'm saying.
Wonderful.
Sorry to
No.
not be, I'm not 100% here, but I'm trying. Thank you.
I think we all heard you. Right now, obviously, this draft does not say that. Can you? Yes. Should you? I have no idea. And where would that go? It would go somewhere relating to non-mandatory payments if that's a direction you chose to go in.
Okay, thank you for hearing me and understanding.
Jared?
Thank you, Mr. Chair. And I hope this is germane to this topic, but I think it would be advantageous if we included definitions of what a mandatory payment is as opposed to a non-mandatory payment. Because especially with this prior discussion regarding tips, one would argue, okay, well, you're not tipping, but you're donating. And that's where it might be a bit confusing for whoever has to follow this future regulation. Just so that way there's clarification in writing saying explicitly, this is what a mandatory payment is. You owe us money, you have a bill out there, mandatory payment, as opposed to a non-mandatory payment such as a tip or a donation or any other type of financial contribution.
Sure.
So I think just expanding on that language would save us quite a few headaches in the future possibly.
So I in the general principle, I definitely agree with you. As I said at the beginning, I think that the organization of this chapter would benefit from a section on payments. And one that, that begins with, the general governing principle that you can't impose mandatory payments for these services, and that you may impose additional fees, non-mandatory, for example. Here are some of the things. And if you want to go with Representative Chase's construct, you could expressly exclude a tip function from being part of the non-mandatory payment menu. That's all up to you. There are, right now, mandatory payment and non-mandatory payment, again, are in the definitions section. But even from the first time I read this proposal, I just felt like it sort of obfuscated what's actually going on here. And that's not anybody's fault. I think that's largely based on the way California has already tried to do it. So I just think we can clarify it.
With respect to the tip and when they ask for payment, I think that tip, if it's included in this, should be excluded from that payment.
That's certainly an option you all would have. You could You can say what the universe is of examples of non-mandatory payments, which, might be helpful. So if you want to mention things like, enhanced services that include expedited payment for a fee, or it's got some other examples in the language already, like you bundle services, one of which is earned wage access services. I mean, we have stuff to go on. I just think telling the universe more clearly, here's what's allowed and here's what's not allowed and here's what's optional might just help organizationally. But the question of whether to ban tips is a policy choice for you. I guess this may be a good place to, I haven't thought this through, so I'm not saying one way or the other, but here we come back again to the evolution of commercial speech in the Supreme Court. And there was actually a case in which the Supreme Court had to decide whether or not the method of payment was actually a speech regulation. And so it was for a haircut studio. And I can't remember it at this point with all of the details, but essentially saying that there was a surcharge or for using a credit card to pay for your haircut may have been a speech regulation rather than an economic regulation. I just have to say that on the record that I'd want to think about that if we're running any problems here about either what we're forcing these people to say or what we're not allowing them to say or do. We have the police power to regulate economic behavior. If it incidentally regulates speech, that's okay. That usually is okay. But in the issue of just outright precluding tips, I think it's probably okay. I just want to think about it for a few minutes. I think it's probably just economic and behavioral regulation that you guys could adopt, and it wouldn't be a problem. But I might want to just read that case again to remind myself of why the details would be different.
And just at the top of page 15, that's where I think it's DFR has the ability to impose limits and requirements on the amount, type, disclosure, non-mandatory payments.
Did you say 15? Yep.
Yeah, top of 15.
Mm-hmm.
And that seems pretty reasonable. Like we're gonna, if the whole point is to make a law that's non-predatory to ensure that Vermonters aren't being preyed upon, I think we have to trust that we're gonna set up laws that do that. So
I think that
problem.
I think you make a good point. I guess I would say this practice is already happening
Right.
in this state. It is part of the business model of one of your witnesses. So if you're going to change that part in particular, I might recommend that you be explicit about your intention to ban that. Because once it leaves here and it goes to rulemaking, you're in a whole different universe. And DFR obviously does an incredible job, but you don't know if that's something they're thinking about, or maybe they hear testimony in the rulemaking process and they decide that's not a good idea. I mean, if you want it to be part of the statute because you feel strongly about it, then it's something to consider putting in the statute. But again, that's a policy decision for you.
I guess for me, I just want to understand more of the reason why to ban it. Because it is a voluntary thing that someone would do. They don't have to.
Right.
They can determine the amount that they want to provide as so long as they're not being, there's not a suggestion there that, they give a $2 or a $5 tip, that it's completely left to the control of the consumer. Then something else.
This is Heather.
Yeah, go ahead.
Can I? Yeah. Well, and I see your point. However, this is for, we do so much for low income people who are struggling to try to get the ends to meet. And I feel that especially if it's a default to a certain amount, that's not right, because a lot of people don't see that. And I also think that when, you're looking at customers like McDonald's, Home Depot, these aren't really high paying jobs. So if people need their $25 to $100 sooner, I just think leaving a tip for a database is predatory. And how many people see it? Where is the tip placed? Is it automatically, filled in with a certain amount? That really disturbs me. And if you're giving someone $25 to $100 early for $1.99, but you're charging $2 tip, I just have real problems with that.
So, and I think we're both saying the same thing, that it's a voluntary, there shouldn't be any suggestions in there. I mean, if you're leaving a tip, sometimes you go to the restaurant and they'll give you some suggestions that you can fill in if you want to or not. But I think, in this case, it should be just left blank. If you want to provide a tip, that's fine. We're not going to suggest $1 or $2 or whatever. It's just up to the consumer whether they want to leave one or not.
And if I may add, Mr. Chair, it's a fairly common practice for a vast array of different applications that are for profit to be enabling the option to provide tips regardless of what service they're providing, be it a streaming service or I mean, Wikipedia solicits, I know they're a nonprofit, but they solicit donations rather frequently and they provide suggested amounts. I'm not comparing the two enterprises, but I think it's a fairly common thing.
Can I talk?
Go ahead.
Oh, okay. So let's say ActBlue or one of those, you go to donate money, right? So this is a different kind of thing. I want my money and I want it a bit sooner. And then to have tips and increased fees is really what it is. Where is it placed on the website? My understanding that there was a amount put into in the testimony. That's how I understood it. And if there is, there's just a lot of problems with that in my mind. So I'd prefer to have no tipping on this kind of service. But if there is the leeway to have tipping, then it certainly should be totally blank and not propagated with a $2 or $4 or whatever. And I don't know who regulates that. And it might be really difficult. But I'd like something to be said specifically about that.
I think the people that are going to do the regulating are sitting here listening to the conversation. And I think if the committee decides that, that should be left blank, and then I think that's the way that they will promulgate the rules on how that would happen. But I think we'll get a clarification from the company Tuesday of whether that box is filled in or not. I don't remember that it was. I think they told us it was.
They told us that it defaulted to $2.
Okay. So that may be something that we don't want to happen. And Jared, Jim, and Logan.
Personally, I think it's a practice that many businesses have been doing for years. As you mentioned, restaurants do it all the time. You don't have to pay it, but you have the option of 15%, 20%, 25%. As John mentioned, you have nonprofits that do it, such as Wikipedia, for-profit businesses that provide the free service. A lot of times, tips are their only source of revenue in order to actually operate what they're doing. And concerning the amount of businesses that are not just operating in this state, but just throughout the entire country, I think it presents a issue that one could argue could cause an issue in terms of interstate commerce, especially if you have an out-of-state company wanting to operate within Vermont's borders in a digital realm, then they have to change their policy that's widely accepted across different states in order to operate in our state. So that's one of the things I'm kind of just, it's good that we can provide disclosures about the people that it's non-mandatory. But it's a widely accepted practice that's been around for years, so I don't see the reason to make things more complicated than they have to be.
First of all, on a personal level, I object to these default tips. And the example that we were given was earnings, was the example. And I just wonder, I've never been to their website. Is there a disclaimer there that says, we're going to have a default tip setting? If there is, and it's clear, that's another issue, but frankly, I'd say no to default tips of any kind.
Okay.
I was just gonna clarify that, yeah, of the three companies we heard from last time, I think there was just one, it was just Earnin that had a tipping, the other two did not allow tipping. But they did say that they defaulted to a $2 tip. And I mostly echo Earnin. Mostly just echo that sentiment, Jim's sentiment, just that I personally would like to see us make sure that it defaults to no tip, but I would presume to allow them to have the option of tipping.
Well, in the printout that they gave us, there's 4 different displays, and the final one says tip if you want. So there is some sort of that, if you want to call that a display.
It just auto selects the. Yeah.
Okay. Anything else on tipping subject?
Thank you.
Thanks, Heather.
Do we reach a decision?
Well, I think committee are we thinking tipping's okay, just that it doesn't default to an amount? So.
Yeah, I wouldn't object to that.
I'm just trying to figure out in terms of businesses that, especially if they operate out of the state, how do we regulate that? Do we email them and say, hey, your IP address is going to a Vermont consumer, and message them saying that, hey, you have to adjust to 0 in order to operate within our borders? I'm just trying to figure out how.
Just so the committee knows, this will be the first statute written in the country on this.
I personally think it's a horrendous idea, and I have no idea how we would actually enforce it. And I think it would dismay businesses having to change the way that they operate business just to operate in Vermont. And I honestly have no idea how we would even enforce it. I don't know how we remotely even have the capacity to do it.
Well,
The regulator can tell us.
DFR would be able to.
They have to be licensed in the state, so if you're not licensed, then.
So if you're a digitally based company and you're providing a online service such as, let's say, AdBlocker, or for example, Wikipedia, in order to have their website operate in our state, if they're soliciting a tip or a donation, they have to get a license within our state boards just to operate, even though they're in a digital realm and may not have a physical presence here.
If we would require them to be licensed. So when we
Okay.
did payday lenders,
Mm-hmm.
they're predatory.
Mhm.
We didn't outlaw them. We just required them to license here as a licensed lender.
Okay. Well, I'm just trying to make sure that we keep it within the realm that it's regarding this particular type of business, because we start regulating this type of tipping, and when we do it for one particular type of industry, then the argument could be made for other types of industries too regarding their tipping procedures. So that's the big thing. I'm just trying to be careful of not to open up a giant can of worms for something that's generally been an acceptable practice for the entire country. And as you mentioned, this is the first time in this country that being put forward, and maybe there's a reason why nobody else has picked it up yet. So that's just my 2 cents on it.
Or other, California has done it, but not by statute, by rule.
Hmm.
We'll certainly hear from Earned In of, that decision, to keep it blank, if that's gonna be a big problem for them or not. We'll hear from them, and then we can make a decision.
Just to point on the issue that he's talking about, making this broader. When you order from Domino's and it's delivered, there's an add-on to it. But they put a disclaimer on the receipt that says, this is not a tip, please tip your drivers. But there's a fee that they add. That doesn't go to the drivers, goes directly to the business. Yeah. And that's not a bad idea to make it broader at a later date.
Thanks. Thank you. I think, isn't it accurate that California has reached agreements with some of these providers, consents basically, but not adopted formally yet the rule itself?
Okay.
I believe that's the testimony. Yeah, we can move on. This is a good issue. It comes up with digital services. I think they do have Vermont IP addresses, plus you have to know your zip code to be able to get all your information about where you're an employee and your employer is and your address and all that jazz. And if the state has the ability to regulate businesses that are conducting activity in this state. But you are also correct that there is a balancing, when you start talking about regulation of businesses and impacts on commerce and interstate commerce, there's a balancing act in the Dormant Commerce Clause that does weigh the putative local benefits basically against the costs to commerce. And if it's unduly burdensome, that's a strike against you. So it'd be fair for you to hear from the industry what the burden might be to have state-based individualized protocols for provision of service. That's not it's not definitive, but it'd be helpful for your record to know. All right, so we have our prohibited acts and practices. These are the things you can't do. These are largely the same. I'm gonna just move ahead to 8. The proposal here is to strike that out. This relates to data disclosures, collections, disseminations. The reason this is being removed is because these entities, licensed as they would be by DFR, would be subject to all the other already existing and quite extensive data privacy requirements that apply to other licensed entities like licensed lenders. So that is by existing department rule. They can talk to you more about what that entails, but it's more intensive than just what's in subdivision 8 here and would afford pretty significant consumer protection.
I'm playing the piano.
Somebody's giving us a little Moonlight Sonata. All right. Gonna end your Friday. I'm gonna go take a nap now. I'll be here every 6 months. 9, 10, 11, 12, I don't know. There could be value to keeping them all in here. I mean, is there value in simplifying, just saying don't commit fraud or make false deceptive statements to consumers or regulators? You can maybe collect those. 13, I think this is also sort of standard language that the department uses. Let's see, on 13, we've got some new ones here. 15 says, you can't discriminate, but it's not discrimination not to contract with somebody if they don't have capacity. I don't think anybody necessarily would read 15 to require you to contract with a person that didn't have capacity, but sometimes we need to cover all the bases. So 16, 17, 18 are all new. And you'll want to spend some time on these with folks around the room. So right now, again, this is what a licensee shall not do. They shall not pay, advance, or otherwise disperse aggregate outstanding proceeds to any consumer exceeding the lesser of 80% of such consumers' earned but paid income or other maximum amount of proceeds as the commissioner may adopt by rule. So you are limiting the amount of the advance in this case, and there's brackets and bolds around 80 because, I mean, of course, it's a policy choice. First off, whether to do so. Second, what the right number is. Third, are there other, circumstances that should predict or command what those right values are. 17, you shall not require, create, accept, perfect any security interest in or pledge or hypothecation of any collateral, hold, possess, control collateral, property or assets of consumer in connection with providing earned wage services. I almost feel like that should go into if we did do it a separate section, but basically like what it means to be non-recourse, even just the word non-recourse. I mean, if you hang around in house commerce long enough, I assume you know what that means. But for the layperson, we might do well to spell out a little more clearly, what it means for these services to be offered on a non-recourse basis.
I have a question about the 16, the 80% thing. Because it seemed like all of the services we looked at had some sort of limit, but then at least one of the services had the bonus thing where they could basically get their friends to sign up for the service and then they could get more than the 80%. And I was just wondering if, it was like, I forget what it's called. It was like, I don't know. Bonus
Sure.
thing here.
So I believe that 16 would preclude you doing any service that by
Bumps it.
some additional element bumps you beyond
Okay.
statutory value.
Okay.
Could, do you have to limit that in statute? No. It does say such other maximum amount of proceeds as the commissioner establishes. So
Okay.
even though there is a statutory standard, that could be changed by rule.
Gross or net, do we need to give it a more clear definition? I just,
Could be worth specifying if you want to, if you think it's necessary. That could also be in rule. It's up to you. 18, you shall not pay, advance, or otherwise disperse proceeds to a consumer in virtual currency or in an instrument denominated in virtual currency without the prior approval of the commissioner in a writing expressly referencing the subdivision other than a virtual currency issued by the US of A. So if we get to the CVGC model, we're all in trouble anyway. Just kidding. I don't have an opinion. Doesn't seem like it's gonna happen. No Bitcoin or Ethereum or Monkey Coin or anything else, unless the commissioner says, okay. Sorry, I'll
and we have others.
Yeah.
No, not those.
So some work happens here in the applicability of other state laws on page 14. Proceeds provided to a consumer by a licensee in accordance with this chapter they're not subject to the licensed lender statute. But you'll see in A, we struck out, it wouldn't be considered credit. They're not creditors, and they're not subject to the truth in lending. I would be interested to hear everybody around the room talk about the implications as they intend them for this section. B, licensed lender. But if you provide this money, you'll see here in B, without a license, then suddenly you are considered to be lending money under lender statute and for purposes of the Consumer Protection Act. And it could be, to Title IX of, that's the whole thing, so that includes that. And it could be a wage assignment under 20, okay, got it. 23, 24, 22, 35, got it. And then the third one here, so proceeds provided are deemed to be debt for purposes of the Consumer Protection Act and rules adopted by the Attorney General. They're under, okay. So that brings with it a whole host of, you can't commit fraud, you can get assurances of discontinuance, there probably are private rights of action, et cetera, et cetera. I can let them speak more to what they all want to accomplish in these changes. Rules are still available to the department. They've added on page 15, including imposing limits and requirements on the amount, type, and disclosure of non-mandatory payments. So again, that goes to the whole discussion about tips and other types of non-mandatory payments. They could limit those. Is 2308 new and I just didn't highlight it, or was that already here? Does anybody know? It is new. I thought so. I thought so. I failed to highlight that. So this expressly authorizes a private right of action against a licensee or against somebody who should have been licensed. And also there are cumulative powers here in B available to the AG's office under the Consumer Protection Act and to the department. We have new sections about license applications and fees. So on page 16 here, remember when you redid parts of Title 8, you did a common set of provisions that relate to the license structures and the fees. For the purposes of this draft, I have put those at 1,000 and 1,000. I don't know if that's what you want, but that's what it is right now. It's comparable to other types of licensees. So we have our initial license fee and initial application and investigation fee of 1,000. And then this next piece, section 3, is for the annual renewal, and that is 1,200. So they can speak to the amount and basis of those fees.
Don't get too worried about the fees. Once this bill leaves here, it goes to Ways and Means, and we'll let them investigate the fees and make the determination of where they should be.
So section 4, 8 VSA 10-2025, this definition, adding earned wage access service providers here. So sometimes this can be kind of hard to follow. There's a definition of financial institution, and that's like a state or a federal or other financial institution for purposes of other parts of Title 8. But then for purposes of consumer protection, it's sort of an enhanced definition of financial institutions. So it includes banks and credit unions type financial institutions, but then also the other things that we separately regulate for purposes of these consumer protection provisions, which also includes the rules I alluded to that provide the consumer protections that will supplant the subdivision previously. So here we are adding earned wage service providers so that they get captured and are subject to the consumer financial protection provisions applicable to all those different types of licensed entities. 5, this grace period concept, I want to, again, this is to the folks in the room who have not had a chance to see this language. I'm welcoming of critique and improvement, but basically we're saying here, if you are already in town, you're already providing the service as of this past January, you can keep operating through December of next year or until you get a rejection letter for your application, provided that you submit this timely application by, before January 1st of 24, and you are otherwise in compliance with the provisions that are to become law. So what that would mean, at least the construct now, is this would actually take effect on July the 1st. The way it's written previously in the statute, that license requirement would attach to January 1st. This would afford you that grace period during the pendency of the application process. I do think we can pull that date down somewhere around here and harmonize all this together. So the session law lives in session law and the statutory law lives in the green books. I appreciate your patience and indulgence. This is a work in progress, and I probably could have avoided confusion by having more opportunity to engage with the good folks who have done so much hard work on this, but I just haven't had time. So the work will continue.
We appreciate having you here.
Oh, thank you
Hey, David.
for the moment. All right. I'm gonna stop sharing now.
Commissioner, would you like to add anything to the conversation now or continue to work with David to finish drafts up and then come back to us on Tuesday with thoughts? Leave it up to you.
I think Ethan just had a few comments on that. And
Okay.
hopefully you have any questions.
Okay. All right, up, Ethan.
Sorry, so I will try and be a little more brief than I was the last time we spoke, so I apologize about that. Didn't necessarily leave a lot of room for questions. So just a couple things that I want to provide color on in terms of our changes. The first, which David clarified, I think there was testimony last time around that was, based on a California rule, and I certainly left the hearing thinking the California rule was already in effect, and I was, running around trying to find it, and all I could find was a proposed rule that was still in like comment and rulemaking. So I have confirmed that California rule hasn't been adopted, but it has been proposed, and that process is still ongoing, and get the sense that its passage was imminent. I was going to say next, in terms of this markup doesn't reflect the comments of industry, and we didn't sort of negotiate it with industry. We had a brief conversation with Earnin immediately after our prior testimony, where they sort of indicated that they were generally okay with what we said, and then we had subsequent calls with PayActive and Daily Pay, which are the two companies that testified before. They have not seen this draft yet, or any of these changes. We didn't want them to see it before the committee did. I imagine they're going to have some input and some suggested changes and some insights, some of which will be valuable on how this could impact their business in ways that we didn't anticipate or necessarily intend. The other thing that I just sort of point out is that there are many other companies and models in this space. I think there are 3 sophisticated entities that have been represented here that have, sort of legislative liaisons in-house or that they've contracted with. There might be other models that would be unduly impacted by this in ways we don't necessarily intend. And the purely hypothetical example that I'd come up with is, say you have an employer integrated earned wage access thing. They don't offer a free alternative. It costs $1, and either they charge the employer or they charge the employee, but their model is, they offer this service at a fair price. That's not allowed anymore. I don't know if that's our intent or anyone that's doing it. I'll just say we sort of had a lot of discussion around this tip model. My understanding is this bill was drafted primarily by Earnin and their advocates and representatives, and so it's based around the tip model, and there's sort of a fundamental concept of it that you have, you break the world into mandatory payments, and all mandatory payments are prohibited, and then you have non-mandatory payments, and non-mandatory payments are generally allowed. And some things that look a little bit like mandatory payments are are deemed non-mandatory as long as there's a free option. So, there are different ways to come at this. I understand in some other jurisdictions that the employer integrated models have a version of a bill that they've proposed in other states that, excludes the tips in the direct to consumer model. And I know some other states have, considered bills that only include a direct to consumer model. Based on our conversations with you previously and the committee having proposed this draft, when we did our markup, we sort of assumed it was the intent of the committee to sort of allow the models that we'd heard testimony on and that were sort of, allowed in your internal bill. But or initial bill, but I don't want to suggest that that's the only way to come at this particular issue. There are other ways. And I agree with David about the structuring with the mandatory and non-mandatory payments and a lot of substantive provisions being in those definitions being clunky. I would also be, you could also do it of just having permitted payments. And these are the sorts of, payments that are permitted and anything else isn't. On sort of the next topic I want to talk about, just on the tips and the First Amendment sort of issue. I think they're and I'm not a constitutional lawyer, so take it with a grain of salt. I say they're probably, but my understanding is that you'd have First Amendment issues if you'd say, you private citizen cannot give $1 to, anyone you want to give that $1 to, as long as it's not in like some sort of criminal transaction, right? People have certain free speech rights in terms of how they spend their money. But I will say we as financial regulators, a big part of what we do is regulating the sorts of fees that are charged by financial service providers, and the manner in which they solicit those fees. And we have a usury law and oftentimes in sort of regulated financial services, there can be, differences from state to state, right? We have a usury statute in Vermont that looks very different than what they have in Utah or South Dakota or some of these other places. There are ways that companies get around that, but it's like, you become a federally chartered bank and then you're not subject to, Vermont restrictions on your fees, and you can go anywhere in the country under your, with that preemption. So I just sort of make that distinction that, there are a lot of, in all the, areas that we regulate at DFR, generally there are some state specific provisions and just sort of the nature of regulated industries, and how we have approached this is thinking about it in the same as being something analogous to our licensed lender statute, where we already impose a licensing requirement on lenders. And as you talked about, that's, goes to the payday lenders. So we sort of looked at it as being something, similar to that in terms of how we approached it. So some of the things that when we were deciding whether to include something, we looked at what some of the, corresponding requirements were that we impose on licensed lenders, just because there are, elements in which the two products are similar. I would be, so I said I'd keep it short. So I will, I do want to make sure I open it up to all of you for any questions you have. We're happy to give you, provide more color for why we propose different changes. The one other thing that I would point out is, we have this thing with non-recourse, and again, I don't disagree with David in saying that definition has gotten clunky, but we changed it up a little bit to basically say, instead of these are 5 things that are prohibited for non-recourse things. We said, you're only allowed to collect or attempt to collect these things because they're supposed to be non-recourse in these 3 ways, in such other ways that are like expressly allowed by the rulemaking process, just to really tightly constrain that. And I'd say one of our concerns is, we sort of talk about non-recourse. It's, they can't go through the judicial system to enforce debts. A lot of our, provisions, regulating debt collection, and where a lot of the issues come up with our non-judicial means that people use. So we did constrain it somewhat tightly, right? So now there only ways you're allowed to collect are there's a an ACH draw model, and there's a drawing direct out of payroll. And then we started putting, you can also give someone an invoice, but you can't give them an invoice every day for the rest of their life. Limit it to 3. And then we sort of have something in rulemaking. So again, this is something where, there may be other models that people collect these by that would not be offensive, at all to us. And they're simply not at the table here or on this call to give us input on it. The rulemaking in order sort of option does allow us some leeway to expand that more. But I just wanted to let you know that we had, constrained it quite a bit. And if you wanted to, to some extent, you could even, the non-recourse definition is less important in some ways because we're even saying it means you can't collect it except in these expressly permitted ways in this other part of the statute. But, we also thought it, doesn't hurt to, belt and suspenders and leave in the original language saying, you can't sue them in court. You can't do X, you can't do Y. So yes.
I have a quick one. It seemed like we're calling them financial institutions at the very end. That was an add-in, and I'm wondering what kind of protection that affords to these companies.
So
I would imagine the only reason we did it was to give them some kind of protection.
Yeah, so I was just so it was alluding to, we have like several different definitions of a financial institution. So this, I was exchanging the definition of a financial institution in our financial privacy statute that applies to financial institutions. So my intent there was to just have that statute apply to them. I suppose one thing that we should double check, and I'm going to confess that I did not, is just see if there's anywhere else in Vermont statutes that references that same one, because we have another license type, the debt adjusters, where we said that, where we didn't amend that definition of financial institution, but in the statute it says the financial privacy statute will apply to debt adjusters. So can run that down a little bit more, but basically we wanted to have, instead of having something, this sort of short paragraph about use of financial information, we wanted it to be the same thing, that the same rules that apply to all of the other financial institutions that we deal with, which is our, financial privacy regulation and our in this financial privacy statute. And thought that was the best way to do it, because there are all sorts of things in both of those that, we had, what was originally in there is, you can't disclose it without their consent. While in our rules and regulations, you can disclose it to the tax department without their consent if they come asking. And there are all these, other times when, disclosures are allowed. You have to file, a suspicious activity report with, the federal government or with DFR. That's, you don't need a consent to do some of those things. So all of these things were already very well fleshed out in these long provisions. Those provisions already apply to licensed lenders. We figured rather than just have this sort of relatively short one, let's just apply the same rules that we apply to everyone else we regulate.
questions? Jerry?
So just to clarify what you mentioned at the beginning, so this bill was originally worked with the company that operate off the tips, and you mentioned that something similar has been in California, but it's not necessarily enacted or at the rulemaking stage?
There's a rulemaking stage in process. So there are proposed rules and there have been comments on the proposed rules, but the rules haven't been adopted.
Okay.
California has entered into memorandums of understanding with several individual companies that sort of, delineate what they
Okay.
can and can't do.
So in terms of memorandums, it's just kind of a patchwork of semi-regulations that are working with those companies, but these larger actual rules in terms of a law do not exist anywhere else in the country.
That's correct.
Okay, I just wanted to clarify that.
So I think one area that you're probably gonna have a lot of heartburn over is private right of action.
And yes, and I should have mentioned our rationale behind that. And that's that in Vermont, even though it's not expressly spelled out in the statute, there's a provision in the licensed lender statute that says, loans, there's a, sort of a negligent or unknowing violation of the licensed lender statute, you're sort of forfeiting interest. And if you, a more a knowing violation, that the whole loan is null and void. So we've traditionally, the courts have sort of interpreted a private right of action under the licensed lender statute. And our thought was, again, to kind of in the interests of parity, create something by statute, in this new one, just creating the same thing. There are upsides and downsides to a private right of action, and it can make things difficult for a company. One of the things that I've thought about is, this is probably going to be a Vermont specific provision. Like usually the fees in these individual advances, we're talking $100 and a $2 fee or something like that. For enough consumers to have been wronged in a large enough amount for any lawyer in a state to take on that account or that case, it will probably be, a significant enough bad act that you're not going to feel too bad about there being multiple, avenues of recovery against that bad actor. That's not to say that every, private litigation is meritorious, but, certainly in our security statutes, we have, private rights of action, we have, regulator, administrative authority. This is a little different, but I think, why we included it, because we'd mentioned it in our testimony and again, we didn't have a lot of time to get your feedback on it because you had another commission. And also that there's a private right of action that exists in the licensed lender, context. But that's very much a policy question. And, if you decide to go a different direction, we wouldn't necessarily object. I mean, most of our license types do not have a private right of action. And
I think that's the justification that, the advocates are using, is that we don't have that for other entities. Something to think about. Other questions? Garrett?
I would say 3 recommendations. I would definitely cross-reference, see if there's any federal statutes that conflict with this, because maybe there's a reason why other states haven't enacted this. 2, I think it would be worth hearing from businesses that are in the same industry but have different business models. Just that way we have more of a well-rounded idea in order to approach this. And 3, I'm not sure if it's possible, but maybe hearing from legislative counterparts in California that are working on this issue and having their opinions on it. Because I'm just a little nervous enacting a piece of legislation that has originated from a different state with one particular company putting input onto it, but nobody has actually put it forward yet. So it just has me a little concerned. I'm just trying to get as much information as possible, just make sure that if we do put anything out there, it's rock solid and that we're covered. And it's not providing a fair or unfair advantage for any business, and that it equally protects the consumers in the same regard. So, thank you.
So I think if we can work with David on refining the language, but also work with people that have brought this to us to find out what their, how they, I don't think that we're gonna be able to post this out on Tuesday. I think there's gonna be more work that needs to be done if the other side hasn't, the ones that brought this to us haven't been able to work with everyone to try to come up with an agreement with everybody. So if we can start that process on Monday, if everybody has the time to do it, we'll come back again Tuesday and see what the new product looks like. Talk to the people that we've invited in, along with you all, and see how close we are to an agreement on the legislation and go from there. I think we all need to remember too that, if there's more companies out there that have different models, once we pass it in the House, it's still got to go through the Senate. So there's time for them to come in and explain what their model is and why they should be included in this. I think we're all open to that, and I think as this evolves, there's nothing that says that we can't continue to make sure the statute evolves as well.
I just should add one point. There were, we did hear from the two employer integrated models that you heard before. Right. One of them, PayActiv, did provide comments to the committee, which we saw, and what those comments did is they made some definitional distinctions where they defined, direct to consumer, products and providers, and defined the employer integrated ones, and then had a new definition that would cover both of those. The only reason we did not adopt that is because the comments didn't have any different substantive requirements or prohibitions for those two different types. They're treating them the same. But both those companies did express to us that it was that they thought it was important to distinguish between the two models in the legislation. Again, the reason that we didn't do it is that any consumer that's savvy enough to be reading this legislation, we didn't think was going to get confused. I think that's going to be few consumers, and if we weren't imposing a different requirements on those two models, we didn't see the need to make that change. With that said, if you wanted to make that distinction and have some different requirements for the two models, for instance, if in the employer, integrated model, you didn't need to have all of these, free options, built in, because there's sort of this other protection with the, employer having opted into it, or, you wanted to treat them differently. We're not opposed to making that distinction. When they made the suggestion, didn't object to their language per se. We just viewed it as a necessary change because we weren't doing anything with those terms. Though in fairness, the one thing that they were suggesting was, in the application, they'd have to identify which model they were in so that they could be, categorized differently. But we didn't think that was DFR retains a fair amount of discretion in terms of what information needs to be provided in the in the application process and that sort of thing. So we just didn't feel the need to enshrine it in statute, but I wanted to point that out because I imagine when they do come with their comments on this draft, some of them will propose making that distinction. I just wanted to put it out there that, we didn't oppose making that distinction. We just didn't think it was necessary at this time.
It might be like I was when I looked around on various sales pages for these apps, like some of them white labeled the service, and so there might actually be a case for letting the consumer know that they're giving their bank access and stuff not just to their employer, like making it clear that there's now a third party, even though the company can white label it and maybe the consumer doesn't know that their employer's using a third party.
Yeah, I mean, I think, I think our idea there was just to keep it, integrated with the other financial privacy provisions that we already have in the statute. And admittedly, I'm not an expert in the labor law stuff, but there are, I have to imagine that there are provisions there that deal with, how you share information with like payroll service providers and things like that. And I don't want to. There are probably landmines in there that I didn't want to step on.
Other questions at this point? Okay, I think, we have, representatives of some of the companies that are looking at this, and if you can touch together on Monday and maybe gives, if you have a chance to give comments, maybe try to work some issues out. That'd be great.
Mr. Chair, are you speaking in terms of industry and DFR or?
Yes.
Okay, great.
And then, consult, then, working with David as well. If we could do that, it would really move the needle a lot quicker than having to, look at the draft on Tuesday, then hear from industry and say, that we don't like this. And then we got to find out from DFR, what can we do and what can't we do? And I think it'd be easier if everybody could sit down at the table and work it out so that everyone's comfortable with the final product that we put out. Does that work for everyone?
Yes.
Okay, great. Question? David, anything?
I just don't think that for Tuesday, that's a realistic timeline.
No, I agree.
If we're gonna have to, because I think what needs, if I may, I think if you would, as a committee, as a chair, would like me to advance this draft to a place where I think at least frames what the outstanding issues are, and then send that to people. Yeah. That way they can all be working off the same thing rather than, the combination of my comments plus my half-finished language.
I agree.
And then if they need to take more time individually or together, that's fine.
Okay.
I just realistically, I won't have until Monday afternoon probably to be able to really focus on this.
So I think what we could do is have a check-in, see where everybody is, on Tuesday. See what's going on, and we could maybe shuffle things around in the agenda to move it later on in the week if you need days to work things out. And if we get to a point where everybody agrees to disagree, then we'll have to decide whether to advance it or not. Okay. So I think if there's no other questions, I think we're good for today. So next week, again, we'll schedule says.
Thank you for coming.
So we'll start with H10 at 9. And then same in the afternoon, we could continue on H10. We'll just probably get an update at 2 o'clock on 87 to see where we are.
We can, thank you.
And then we'll figure out where we are and what's going on. So have a good weekend, everybody. Thank you. Thank you to the department. Aaron, thank you.